Hello, everyone, and welcome to our webinar today, How to Navigate FDA's Non-Inspection Enforcement Actions. My name is Taylor Minks, and I am the marketing lead here at Retica Systems. Retica Systems is a data analytics platform helping life science companies improve their quality and stay on top of evolving regulations. Our proprietary process transforms one of the industry's most complete data sets, aggregated from dozens of health agencies and Freedom of Information Act sourcing, into meaningful answers and insights that reduce regulatory and compliance risks. Founded in 2010, Retica Systems serves over 200 customers in the pharma, medical device, and food industries. Our presenter today, Neil Spirito, is principal partner at Spirito Law. Clients call Neil when complex government regulations or decisions threaten their company's future by jeopardizing transactions, mergers, acquisitions, licenses, new product applications, enforcement proceedings, administrative actions, litigation, stalled applications, or civil and criminal investigations and complaints. So he works in a lot of different areas. For over 2 decades, Neil has helped his clients navigate complex government regulations or decisions that impact their future. He has advised all types of life science companies on a broad range of U.S. and international regulation compliance challenges and issues that arise in government regulatory approvals and actions, transactions, mergers, acquisitions, licensings, and etc. As a reminder, please use the chat feature that we have, and we'll have a live Q&A with Neil at the end of the webinar today. And now I will pass it on to Neil to begin.
Thank you very much. Thank you, Taylor, and thank you, Retica Systems, for having me back. Last time I was here, I spoke about the consequences of inspections, the warrantless search, and today I'm going to speak about non-inspection enforcement actions, which are more common than I think most people realize, and they can be just as significant as most people realize. As Taylor said, I have been in the industry for 30 years, almost 20 years in private practice now. I handle a wide array of these issues, and I find Retica.com, the database, to be an extremely efficient and comprehensive way to gather knowledge. So without further ado, we'll get on to our first slide. All right. Non-inspection enforcement actions. What does that mean? Okay, so as you figured out by now, FDA actions not originating from inspections. What is the other reason why FDA are really the other reasons why FDA may initiate warning letters and actions? These days, the FDA is using voluntary records requests. They're also checking for unapproved drugs and devices, making drug and device claims. Advertising and promotion account for a lot of non-inspection actions. OTC drugs by monograph and import-export violations, customs referrals can all be sources of non-inspection actions. Improper distribution is another one that we'll talk about today. So let's go on to the next slide. And I think this is something I always want every client to know, and that is that FDA is going to use evidence of these violations to bring enforcement actions against companies. So to avoid this, you really have to understand the regulation and the law behind the regulation. You have to know your rights, when to call legal counsel, and have a detailed plan to avoid and deal with these alleged violations when they occur. Okay. FDA will broadly, in general, in inspections, but in non-inspections as well, ask for information they're not entitled to. When they ask for information they're not entitled to, once you hand it over, that can be used as evidence against you. They'll be saying that you freely allowed that information to pass to them. You gave it to them. So it's important for you to funnel what FDA is allowed to have and what FDA is not allowed to have. Now, when allegations arise, you have to be sure to have proper, thoughtful answers. And you want those answers reviewed by your legal team to respond and handle these inquiries or actions. Otherwise, actions can result in a long, expensive process to resolve. So, what is the takeaway from all that? The takeaway is know your rights, work with your attorney to know when to call your attorney. It's very important that you never, ever lie to a government investigator, inspector, agent, etc., because that can be a felony offense. Instead, you have the right to remain silent. You can use that. And if it's significant, you have the right to call your attorney and have your attorney present when you're being questioned, or at least to consult with your attorney. And those are things that you want to do, because if you tell me, okay, what you did wrong, it can't go any further than me. But if you put this out there in public to the government, then, or to other people who can testify against you, then this will create a problem for you in the longer run. So let's go on to the next slide. A few basics. I'm going to talk to you a little bit about adulteration, although that was mostly in my inspection-based talks. Misbranding is huge in actions related to non-inspections, and patient-doctor complaints, FDA Med Form 3500. Okay, and I think most of you are familiar with what's an adulterated drug. Okay, not in conformance, GMP, prepared, packed, in unsanitary conditions, etc. And we can go to the next slide here. And it's readily available in 21 USC 351. Poisonous, deleterious substance, contents injurious to health, contains unsafe colorings. And we can go on further here to the next slide. Your strength or purity is not proper, your advertising, and this is really is caught in non-inspection. And that is your drug is not, or your device is not what it purports to be in the process. So in other words, you have a drug and it is supposed to be 10% active ingredient, 20% active ingredient. It's supposed to have a delivery system that puts a large percent of the active ingredient into your system. FDA starts getting complaints that the patients aren't getting better, the patients are getting sick, the drug is not working. They go take your drug off the shelf and analyze it. If your drug is not of the strength or purity that it purports to be, then you're going to receive a visit from the FDA, and maybe not even a visit, maybe a letter or a Zoom meeting, and they're going to explain to you that you're in violation of this. Once you're in violation, then they have the option to take other remedies, legal remedies against you. Labeling is false and misleading. This is definitely a non-inspection issue, okay? Because what's going on is the FDA takes a look at your label. Yes, they look at your labels in inspection, but they also look at your labels outside of inspection, all right? These labels are out there. They're on the internet. They're in magazine ads. They're in various areas that the public would access them, television, DTC ads. And so when they're looking at this label, if it's false or misleading, it's going to lead to an action. A common mistake people make is they don't put the name and place of business on the product. I get a lot of calls that say, well, we did put this affiliate of ours on there. Okay, that's a subsidiary of ours. Well, do they distribute it or market it? No. Do they manufacture it? No. Then you violated the rule because you have to have the person who is marketing and distributing or the person who is manufacturing on the label. And the reason is accountability. The FDA wants to be able to come in and talk to you. They want the patient or the doctor to be able to call your 800 number and get an immediate answer. And the other thing is labeling required is not prominently displayed and understandable. And that's another one that inspectors catch in non-inspection issues. So we go further here into the next slide. Okay. This is the main thing about, and you can skip this slide on to the next one, but this is the main part of misbranding that you have to understand. The product can leave the factory perfectly documented, perfectly made, pass all of the release testing, assays, proper bottling, packaging, labeling. It can go out into the world. You can run an ad that makes a claim that's outside of your indication. When you make this claim outside of your indication, you've now misbranded the drug. Okay? And I can remember I had a client who came in with a device at one time. It was a foreign client. They brought it into the US and they didn't get their indication correct for this device. But they sold the device for an indication that was outside of their label. Consequently, they got in a lot of trouble with the FDA. They came to me, and sure enough, they needed to expand their notification, their clearance, in order to have this device be sold for those issues. In the interim, they had to withdraw the device, withdraw the ad, and withdraw the claims that they made in promoting that. And that's expensive. So we want to try to avoid that. And labeling doesn't bear adequate directions for use. Consumers will complain about this. Okay, so if you have a device or you have a drug and the little label from the pharmacy doesn't give the appropriate information, so they go online and they look at your PI, and your PI doesn't tell them whether to take the two pills together or the two pills spread out in a BID format. This is, again, going to be an issue for the FDA. So misbranding is one of the really big issues because it occurs after the product is out. A perfectly good product is out on the market, and then your promotion or your display. One of the famous ones, Neurontin. Neurontin was approved for seizures. Neurontin went out on the market and was very effective on chronic pain. Neurologists were using it in both areas. The company took an approach towards marketing it for chronic pain. They didn't have the indication. Long story short, this all got wrapped up with a bunch of other issues. And when they all became Pfizer, Pfizer ended up paying $2.3 billion to settle out all these different issues. Okay. And so that was the same thing with the COX-2 inhibitors. They were supposed to be they were supposed to have a good cardiac profile, not have the same profile as the standard NSAIDs. In fact, they didn't. They had an issue. And consequently, therein went and became an issue, non-inspection issue. Okay, and here's the thing, and this is an old story that everybody uses to illustrate this. There were actually products where the product was out on the market, and people would publish little books or pamphlets or articles. The people who distributed and promoted the brand, And this would actually, in the day, go on to the drugstore. Sometimes it was actually on the other side of the drugstore on the magazine or bookshelves when they used to have those. And yet the FDA found, and the court found, that that was still enough to make this a misbranded product because it was closely associated with it. So the key thing to remember here is you can misbrand your drug even though the drug was not misbranded at the time of shipment, and this results in a non-inspection FDA action. All right, so let's move further. FDA Enforcement Authority, administration, warning, untitled letters, product recalls, civil penalties, debarment, and withdrawals of product approvals. So what happens? Your first level is going to be a warning or an untitled letter, in which case the FDA tells you you have a problem. You have advertised this improperly. Your product is not what it purports to be. You've made an unapproved claim for your product. And so the first thing they're going to do is send you a warning letter. The most important thing is not to ignore the warning letter. I know most of you know that, but you'd be surprised how many people don't. So take that warning letter, that untitled letter, and take it to your regulatory people and your regulatory attorneys and craft within 15 business days a good reply to that, allowing you to present your side of the issue, okay? Or in the case where you may have done something wrong, how you're going to correct that going forward. It could be as simple at that state of as destroying an ad, etc. Now, product recalls are interesting because it depends on the type of product recall you get, and they vary. You know, a product can be recalled from just your distribution chain, in which case what's out there on the shelves or has already been consumed is not a problem. Generally, that's for something minor. Documentation wasn't proper. There's a mistake on the label. There was a printing error. The bottles weren't sealed properly, a minor issue. But it can be all the way down to going and finding the products and taking them back. And product recalls are expensive. And then you're responsible for replacing that product in your distribution system. Civil penalties result from suits from the Department of Justice. The Department of Justice represents the FDA in civil matters and criminal matters. So when civil penalties, okay, when the Department of Justice sues the manufacturer, okay, then civil penalties can be awarded. There can also be seizure, and there can be several different other disgorgements of profits. So there can be a lot under civil penalties. Most of these cases result in something called a consent decree. And if you've operated the business, you know how tough it is to operate under regular authority and regulations, let alone if you add to that the government supervising everything you do under interim controls and very, very strict inspection practices. And there's debarment, and that rarely happens. I've had two individuals in all my days of practicing. Both were not my clients who were discovered to be debarred. And basically, you have to have basically they're people who generally knew they were doing something wrong. They had a mens rea of doing something wrong. And they made a decision that even though the product was bad or inappropriately marketed or whatever else, they made the decision that they weren't going to remove the product or recall the product or stop production because of quality issues. Instead, they willingly move forward. And if there's mens rea attached to what you do, you'll find yourself on the other side of a criminal complaint or at the least a debarment. So make sure that if it's an honest mistake, it's documented as an honest mistake and there's no mens rea involved in this. Withdrawal of product approvals, that's the FDA's hammer. They can withdraw your product if it's created problems. They'll ask you for a voluntary withdrawal. It's not really voluntary. But one of the things they will do is hold your applications or place you under something called an application integrity policy. The application integrity policy will prevent you from moving forward with any applications until you've cleared your issues and they're sure that your data is honest and reliable. Judicial, civil penalties, seizures, injunctions, criminal prosecutions, and disgorgement. Okay, we've spoken a little bit about that, and we spoke about civil penalties. And civil penalties can be huge fines. They can be, suits won by the Department of Justice. At one time, when I used to go to, there was a particular enforcement conference, one I still teach at, or I taught at last year, which basically, one of the presentations is the United States Attorney's Office coming to the stage and talking about the percentage of convictions that they got and the amount of money they assessed in civil penalties. And it was staggering, billions. Injunctions. The FDA will use injunctions. They will go for a temporary restraining order, which they can get quickly, and then in 30 days to turn it into a formal injunction. Your lawyer has to be ready to fight the formal injunction if you have grounds, and otherwise it'll become a permanent injunction, and you won't be able to operate certain operations, certain plants, certain products. A lot of times these days, the FDA is taking the state in with them for inspections because it takes a little bit of time to get an injunction, and it's much easier under the broader power of most states. The state can issue a stop work order for any reason for usually 30 days until you get your day in court. So you definitely want to be very aware of that. I had an inspection, maybe a dozen years ago, where by Friday, the FDA investigators weren't happy, but there was really not much they could do. However, on Monday morning, the state officials walked in, and because generally state laws start with the FDA regulations, they say you have to be in compliance with all FDA law and regulation, but they can be more stringent. And so therefore they find a reason to issue a stop work order. And on a Monday, they issued the stop work order. Now, it was one we were able to get removed because in essence, they really didn't have sound authority in the fact that the violation was not significant. However, it disrupts your operations and your shipping, and you have to tell your clients that you can't ship for several days or a week or so while this gets straightened out. Criminal prosecutions, I think we all saw what happened to the Massachusetts compounding laboratory. Those people are in jail now. And while it's reserved for the more heinous individuals, there are criminal prosecutions under something called the Park Doctrine. And that goes by knew or should have known as the standard. And it's a strict liability standards. It's one of the few places in the criminal law where you don't have to have mens rea. So what happens is you are the president of the company in Washington, D.C. Your California plant has a general manager who's taken shortcuts. They're significant and endangered the public health. The company can be imputed under the Park Doctrine criminal activity because the president knew or should have known, or the vice president of quality or the vice president of regulatory knew or should have known. Okay, didn't have to actually know about it, but should have known. And once you're under a Park Doctrine as the company, while granted it's a misdemeanor, it prevents you from any government contracting, Medicaid, Medicare, VA, all those types of reimbursement. It's significant. And the last one is disgorgement, and I've seen this used several times over the course of my career. And that is where someone has profited from their criminal acts, and the government has gone in and civilly taken back all of that profit. Okay, voluntary records requests are all the rage now. FDA doesn't have enough investigators or enough budget. They were doing what they called remote inspections, which really weren't inspections by law. And this was during the pandemic. Well, now what they're doing is they're sending for records requests. There are two. There is the mandatory, which you have to comply with. However, the interesting thing is that the agency will try to tell you that if you don't comply with a mandatory records request, that it's the same as a refusal for inspection, yet it's not an inspection. So that's when you have to call your lawyer, because we have to hash this out with the FDA to see if a mandatory records request is even proper in the circumstances, or punishment for refusing it is proper. Now, a voluntary, voluntary records requests are called voluntary, but a refusal will have FDA show up for an inspection or do other things to make their point that they want their records. Their reach is broad, and they can do other things. They can scrutinize your advertising. They can scrutinize your promotion. They can recheck all your labeling. They can do a lot of things that'll make your life difficult. But the thing to remember in a voluntary records request is to make sure that your attorney goes over the records you're turning over with your quality people prior to turning them over, so there are no surprises. Okay. And then you have to make a legal decision as to if there are records that should be held back and try to protect them under the court. Although administratively, the FDA is entitled to what they're entitled to. But there are ways to work with that. Unapproved drug claims, off-label marketing of pharmaceuticals, advertising, and promotion violations. Next slide, please. Okay. This is the bulk of where violations occur non-inspection. All right. You've made a claim or said something you shouldn't. It's predominant in supplements. Many times supplements will allegedly make claims that make them a drug. You know, if you say something to the effect that you diagnose, cure, mitigate, manage a disease, you've now become a drug or a device. But you're not cleared as a drug or a device. And consequently, you will be punished for being an unapproved product. An unapproved product, I mean, the FDA has all kinds of ways of, there's a framework called DSHIA, which protects supplements up to a certain point. However, the FDA can still file unapproved drug claims because now you're acting as a drug, so they have authority over you, or GMP violations they have authorities over. And that goes to the inspection related, but the non-inspection related is definitely about claims. So before you design your clinical trial, you want to make sure that you know how you're going to market it, where your market is, and you want to make sure that your endpoints are endpoints that enable you to sell the drug for the claims that are the most lucrative claims. Okay. And approval is limited to specific approved and labeled therapeutic issues. You cannot go around and sell the drug or promote the drug. Hence the Neurontin story for chronic pain when your drug was only indicated for seizures. We see it a lot in medical devices, the lower class medical devices mostly, where someone will invent a new product and they'll say that the vibration of this product will cure your diabetic nephropathy in your feet. Well, right away, that's a red flag because the device, and it's not yet a device, is not cleared. The product is not cleared as a treatment for diabetic nephropathy. Consequently, therein lies the action that FDA will take. Okay, unapproved new drugs, and you can see the violation, 21 USC 331D. Here's the thing, too, that intending that it be used for unapproved, unlabeled uses violates the act. So in other words, if you're a doctor, you can use a drug in any manner you want. The drug or the device company won't stand behind you. You'll be on your own from a liability perspective. But the law allows you to use drugs or devices off labels. Doctors do it every day because there's significant supporting literature behind it. It's a common practice. Years ago at the Upjohn Company, we had a drug called Provera. It was never, ever indicated for hormonal replacement therapy. However, everybody used it there. Finally, with Hatch-Waxman and the ending of what they called DESI drugs, where those drugs grandfathered in to be allowed under their old uses, the Upjohn Company had to file an NDA and be approved. And it's the same for many, many other products that were out there in the DESI status. But one of the things is that today, putting that into commerce would be a significant violation. So you can only actively sell, advertise, and promote the product for what the FDA has cleared, approved, or indicated it for. Labeling. Okay, this is where you get in trouble all the time for non-inspection issues. Promotional materials, booklets, pamphlets, literature that's textually related to the product. And these days, social media. Okay, who is saying something about the product is important. Anyone who is in the promotional chain or the advertising chain or related to the drug has to be very, very careful about what they can say, because all of these things become part of the labeling. We often talk of the label. Some people think it's the label on the bottle, but as most of you know, the label is the package insert. Okay. And so consequently, anything you do that distorts the package insert that you put out there is definitely a problem for the FDA. Okay, because it's part of your labeling. So if your product is a prime example, clients have had NSAIDs that are approved for general pain, okay, and treatment of general pain. I had gone to the FDLI inspection conference years ago as a younger lawyer, and I saw a company that got in trouble for an ad that basically had a sneaker full of nails. It was a podiatry company. And what happened was the FDA said, yes, you're indicated for general pain. However, you're promoting this in a sense that is for the pain of plantar fasciitis, a painful foot disorder, by putting nails in the sneaker and the accompanying text. This was 6 years after the ad was put out. The company had realized that it was possibly on the line, so to speak, and removed the ad. 6 years later, the FDA came in and made them send letters to every doctor, client that ever prescribed the drug that the ad was a mistake. So these things can get cumbersome and expensive. Just trying to find who were the prescribers 6 years ago is not an inexpensive exercise. The term labeling encompasses all of those written or graphic materials. And technically, you're misbranding the product if you have something out there that, is an advertisement, a DTC ad. Back in the day, it used to be a magazine ad. And today it's social media. You really have to be careful about people distorting your label on social media. Granted, there are people out there that can say what they want and they have no attachment to your product. But you have to make sure that anybody who's attached to your product doesn't say the wrong thing. Even, doctors, they ask your salespeople a question. They ask you a question on social media. It can only be another doctor who, in a doctor-to-doctor conversation, can talk about the drug off-label. Okay. And well, there's probably exceptions, probably nurse practitioners and things that are trained to do that, pharmacists. But in general, it has to be a highly trained medical person that can talk to another highly trained medical person about an off-label. It can't be anybody in your promotional or marketing realms. Okay. And be careful if people offer premiums with your products, with books, or people put wrappers over your product. This is all part of the problem. So anything accompanying it, scrutinize. Next. Okay, we're back to misbranding, and I came back to this point not to belabor it, but to create the impression that even an implication. So if you have a drug and it's not 24-hour, but you advertised the drug with a sunrise and a sunset, the moon or stars, then the FDA can say that you implied that it was a once-a-day drug. Now, of course, you'll say, well, we're saying you take it twice a day, morning and night, but basically the FDA's interpretation is going to be the one that counts. And these are all the things that lead to enforcement actions of various types that aren't part of the inspection. And so that's where we are at this point. And now I'd like to open up the the webinar to any questions.
Yes, we do have a
Do
few.
we have any questions?
Yes, we do. We do.
Okay.
So our first one kind of addresses EIRs. They want to know if you have any comments or what are the best practices typically used to address verbal comments in FDA EIRs?
Okay, well, FDA EIRs are issued after the inspection, and they're the communication from the inspection. So this takes us back into inspections, but I don't mind answering it.
Yeah.
And that's the communication between the investigator and the compliance officer. That's him talking to headquarters. As a matter of fact, if you're in violation, okay, if you've had a not great 483, then what you're going to find is that they won't release the EIR to you. The EIRs are only released if everything's okay, and it takes a while to get them. But if the inspector says he has an impression that something's wrong, even though he couldn't prove it, or that he believes in one of your other lines that you weren't running that day, something he observed as not a problem in the current line you were running is going to be an issue. These are the inspector's impressions back to the FDA. And there's not really a lot you can do about them because you're not invited to that communication. What you can do is you can respond to those matters if they're on the 483 in those 15 business days, talking about that. You can also write a letter to the agency, to the center, to especially if it's something that has to go to the center. Say you have a new assay. It's not USP, but your product is biologic and it's got 2,300 polypeptides. And so you had to invent your own. release assay. You can go to the center and you can say that we know that the investigator had an issue with this, and the compliance officer may have an issue with this, but this is why we did it, and justify it to them. But in general, the EIR is really between them. You're not invited to that communication. What will happen is where you're going to end up straightening it out if it's something of significance is in the warning letter if you get one. The issue is this is their internal communication. This is their impression. And so what I would do is have my regulatory people and my attorney marshal the evidence. Okay. If it's something you can go to the center with, yeah, do that. If it's not, then basically have the evidence ready. So when the FDA comes back again to look or questions it, you'll have everything you need to answer it appropriately. But there's not really much you can do about it in investigators' impressions.
Got it. Got it. All right. Well, next question. Do you see the FDA moving away from consent decree?
Never. I think that's one of their big control pieces. And, for myself and my colleagues, that's been a staple of what I've done over the last 30 years, 20 years, and 20 years in practice, and my colleagues do now. And, the civil suit is going to continue. And the way that they control bad actors is with the consent decree. Most people don't understand that the consent decree is a result. It's a settlement. It's a court settlement of the case. So in other words, it has to be bad enough. You have to have not been satisfactory in answering the warning letter. You have to not been satisfactory in a reinspection when they come back to see you. You have to not have been seen as cooperative in correcting these things in order to get sued by the Department of Justice.
Got it.
Or you did something really wrong. Once you're sued by the Department of Justice, it proceeds as any other civil suit. And what you're trying to do is get the upper hand so that you can get a better consent decree, because it's going to end up in consent decree. Now, about 3 years ago, I had a case that went 18 months and didn't end up in a consent decree. We were able to get them to go away because they couldn't prove what they did wrong. And so consequently, I was able to save them a lot of grief by getting the charges dismissed. That happens occasionally. But in general, you're going to be in some type of a settlement with the government. And some of them have AIPs in them now as well. So they actually, instead of issuing an AIP, they included several paragraphs in the consent decree that prevents you from getting new drugs approved while that consent decree is in place. And trust me, it's a long 5 years. The other thing to remember about a consent decree.
Yeah.
It's a long 5 years. Yeah. So it's 5 years once you enter the consent decree, but it's not an automatic release. If you haven't made proper progress, they don't have to release you. What has to happen is your attorney has to go to court and get you released under the same court order that imposed the action, that imposed the consent decree. So some consent decrees can go 10 years.
Wow.
20 years. So yeah, and at that time, don't forget you're paying whatever the going rate is for the investigators to inspect your plant regularly, plus supervision, plus they have a really unique piece in there called a letter of close down. And in your consent decree, what happens is they say, okay, you're giving up all your due process rights if we think you did something wrong. And we send you a letter that's substantial. In other words, they have to have a real reason. Okay,
Mhm.
The court's not going to let them get away without a real reason. If we send you a letter, we can shut your plant down and you really can't do much about it. And that is in the negotiated consent decree. So no, I don't see FDA ever moving away from those.
Makes sense.
That's their bread and butter, so to speak. what do I want to say, control tool.
Got it. Got it. All right. Well, our next question, do you have any statistics on how many warning letters and 483s come as a result of 704A4 requests?
Okay. I don't have the statistics in front of me, but that's why I love Retica. That's why I love speaking for Retica, because they do. You can get the statistics on anything from Retica. And as a matter of fact, if I knew this question was coming, I would have gone into the Retica database, researched it, and given you the answer. So I apologize, I didn't know. But off the top of my head, I don't know the statistics. And I have an idea of the percentages, but I don't want to put that out there because it may be wrong. So trust me, your best thing to do is go right into the Retica. Sure, if you don't know how to do it, Retica is happy to help show their clients how to do it. And you can get those statistics in a nice, neat package. You can also get them outside of that, chasing down the government statistics. But it's not an efficient exercise. It's something that takes a lot of time and energy. And if you can afford Retica, you definitely want to use it because that's the benefit of a site like this.
Oh, thank you. Well, I'll field that question then. I'll take it offline and see if I can get an answer for you guys for the follow-up when we send the video and everything. This next question is also like a statistic type question. Let me find it again. Oh, how the balance of FDA actions not originating from inspections breaks down across pharma, OTC, biopharma, etc. So might have the same answer from you on that one.
Again, Reddit is a great place to get the exact statistics. But on this one, I can tell you that these days we're seeing the most in biologics and medical devices, mainly because they're the most out there. You're seeing a lot of it in drugs, as you always have. OTC is very simple. You fit the monograph or you don't. So it's relatively easy for FDA to analyze your product and see whether you have the right combination and percentages. But overall, I would say that, the FDA is attuned to the newest drugs, biologics, and devices that are coming to the market because that's where your problems occur. Okay. Older drugs, especially generic versions, those are mostly inspection caught. Okay. And occasionally, because the label is of the brand manufacturer, not of the generic, there might be requests for label changes and things because of things that have been observed in the marketplaces. But in general, you're going to see the greatest enforcement in the newest products.
Got it. Got it. All right. Well, I believe that's all the questions we have right now. So that will conclude our webinar. Neil, thank you for speaking with us again. It's always a pleasure to have you. And thank you to everyone who attended today. If you have any questions after the webinar for Neil, you can reach out to us at Retica and we can field you over there, or in a lot of your follow-up details, you do have a link to his LinkedIn, so you can send him a message on there if you have any questions for him afterwards.
Or you can visit my website, www.thespiritolaw.com, and that gives my email and phone information for follow-up questions. I'm always glad to follow up for Retica clients. As I say, it's Retica database is a great place to get your information.
Oh, thank you, Neil. All right, well, everyone, have a great rest of your Tuesday, and we'll see you at our next webinar.
Thank
Bye.
you.